I want to tell you about the morning of January 14th. I want to tell you about it because of a video. Not a video I'm showing you right now. A video that was submitted as evidence in a criminal-adjacent civil matter that landed in my courtroom that morning. A video taken by a bystander on a phone, 11 seconds long, that showed a young man in an expensive coat shoving an older man to the ground outside a downtown coffee shop. The young man was 23 years old. The older man was 66. The older man had been sitting against the building near the entrance with a cardboard sign and a backpack that contained, as it turned out, everything he owned in the world. The young man's name was Tyler Bregman. His father was Donald Bregman, the founder and chief executive of a logistics and freight company with annual revenues in the hundreds of millions. Tyler worked at his father's company in a role I would learn more about later in the hearing. The older man's name was Walter Henley. He was a retired Army Sergeant First Class, 22 years of service, 2 tours in Vietnam as a young man, decades of work afterward, and a more recent and more complicated story about how a person who had served his country for over 2 decades and worked for decades after that had ended up sitting against a wall on a cold January morning with a cardboard sign. I want to tell you what happened when these 2 men ended up in the same courtroom. And I want to tell you what I did, what I decided to do, deliberately, in a way that I do not do in most cases, because what I did changed not just the outcome of that morning, but I would later learn the trajectory of Walter Henley's life. Stay with me through all of it. The 11-second video had circulated locally before the civil claim was filed. It showed Tyler Bregman exiting the coffee shop, stepping over Walter Henley's outstretched legs in a way that suggested irritation, saying something to him that was not audible on the recording. And then, when Walter apparently said something back, shoving him hard enough that Walter fell backward against the brick wall and onto the pavement. Walter had sustained a fractured wrist from the fall, bracing himself instinctively, and a laceration on the back of his head from striking the wall. He had been taken to the emergency room by the bystander who filmed the video. He had received 11 stitches and a cast. He had then filed a civil claim for assault and battery, medical costs, and damages. Tyler Bregman had retained an attorney, a senior litigator named Gregory Pierce, who specialized in exactly this kind of case, the kind where a wealthy young client needed a problem to disappear with minimal public consequence. Walter Henley was representing himself. I read the file the evening before. I watched the 11-second video 4 times. I read Walter's medical records, the fracture, the stitches, a follow-up note indicating that at 66, with documented circulation issues likely related to 2 tours of service in conditions that had not been kind to a young soldier's body, the fracture would take longer to heal than it would in a younger person. I also read something else in the file, something Walter had included, not as evidence exactly, but as context, a single paragraph he had written by hand and submitted with his other documents. I'm going to read you what it said, because I think about it often. He had written, "I served this country for 22 years. I am not asking the court for sympathy. I am asking for what is owed to me under the law, the same as anyone else who has been hurt by someone else's actions. I have learned not to expect much. I would appreciate it if this court would not teach me that lesson again." I read that paragraph 3 times before I went to bed. Tyler Bregman arrived at my courtroom at 9:58 with Gregory Pierce. He was dressed expensively, casually, the way people dress when their casualness is itself a form of display. He looked at the gallery with mild boredom. He looked at the bench briefly. He did not look at Walter Henley, who was already seated at the plaintiff's table. Walter arrived at 9:40. He had walked. I would learn this detail later from the Veterans Coordinator who spoke with him after the hearing. He had walked from the shelter where he was currently staying, a distance of approximately 2 miles, in January, because he did not have bus fare and had not wanted to ask the shelter for it, given how much they already did for him. 2 miles on a cold morning with a cast on his left arm to make sure he arrived early for a 10 o'clock hearing. He was wearing a collared shirt that had clearly been pressed, though not professionally, pressed by hand, with effort, with whatever tools were available to him, by a man who understood that how you present yourself in a room matters even when the room has not been kind to you in the past. His shoes were worn but clean. His posture, despite everything, was upright. His left arm was in a cast, the kind that goes from wrist to mid-forearm, still relatively new based on its whiteness. He sat with his right hand resting on a folder that contained, I would learn, the medical records, copies of his military discharge papers, an honorable discharge, I noted, after 22 years, and a single photograph that he had not yet shown anyone. I called the case. Walter presented first. He did not have an attorney's polish, but he had the bearing of a man who had given testimony before, in different contexts, under different circumstances, but the discipline translated. He described the morning of the incident plainly. He had been sitting where he usually sat. He had not been blocking the entrance. The video confirmed this. His legs were close to the wall. Tyler had stepped over him with what Walter described as visible irritation. Tyler had said something. Walter quoted it, and I will not repeat the specific words here, but the substance was a directive that Walter move along, accompanied by language characterizing homelessness in terms I found ugly even secondhand. Walter had said in response only, "I'm not bothering anyone, son." Tyler had shoved him. Walter described the fall, the impact, the stitches, the cast. He described it without embellishment and without self-pity. He presented the medical bills. He presented the lost income. He had been doing day labor work when available, and the cast had eliminated that income entirely for the foreseeable future. He asked for the medical costs and the lost income and nothing more. He sat down. Gregory Pierce rose and presented the defense. His argument was that Tyler had been startled and had reacted defensively to what he perceived as an aggressive movement from Walter, a characterization that the 11-second video did not support in any way I could identify, and I watched it again in the courtroom to be certain. Pierce argued that the damages requested were excessive given the nature of the contact. He argued that Tyler's youth and the stressful circumstances of the encounter should be considered as mitigating factors. I listened to all of it. Then I asked Tyler Bregman a direct question. I said, "Mr. Bregman, I have watched the video several times. I do not see anything in Mr. Henley's posture or movement that could be reasonably characterized as aggressive. I would like to hear, in your own words, what happened." Tyler looked at his attorney. Pierce gave a small nod. Tyler said, "He was in the way. I told him to move. He mouthed off. I reacted." I said, "He mouthed off. What did he say?" Tyler said something like, "He wasn't bothering anyone." I said, "That is what he told you?" Tyler said, "Yes." I said, "And your response to a man telling you he was not bothering anyone was to push him to the ground hard enough to fracture his wrist and require 11 stitches. Tyler said, "I didn't think it would be that bad. He's old. I didn't think." He stopped. I said, "Finish the sentence, Mr. Bregman." He did not finish it. I looked at Gregory Pierce. I said, "Counselor, I am going to rule on the documented claims, and I will tell you now that the ruling will award the full medical costs and lost income requested. That portion of this morning is not complicated." I said, "But before I issue that ruling, I want to do something I do not often do in this courtroom." I looked at Walter Henley. I said, "Mr. Henley, you wrote something in your filing that I want to ask you about directly. You wrote that you have learned not to expect much, and that you would appreciate it if this court did not teach you that lesson again. I want to ask you what you meant by that." Walter was quiet for a moment. He said, "Your Honor, I've been to 2 other hearings in my life involving disputes with people who had more resources than me. Both times things didn't go how the evidence suggested they should go. I'm not accusing anyone of anything. I'm just telling you what my experience has been. I said, I understand. I said, I want to ask you something else. You served 22 years, 2 tours. You came home and you built a working life. I would like to understand, if you are willing to share it, how you ended up where you are now. I want to pause here and tell you something before I tell you what Walter said. If you were Walter Henley, 22 years of service, decades of honest work after that, and now sitting on a sidewalk, being told you don't belong there by a 23-year-old who has never had to fight for anything, what would you want this courtroom to understand? Tell me in the comments, because what Walter told me next is something I think every person watching this needs to hear. Walter told his story plainly, the way he had told everything else. No embellishment, no self-pity, the specific evenness of a man who has had a great deal of practice carrying difficult things without letting them show in his voice. He had worked for 31 years after his discharge as a maintenance supervisor for a regional transit authority. Steady work, a pension that, while not large, had been enough. A small house he had owned outright by the time he retired at 62. The mortgage paid off after 26 years of payments, made on time, every time. 4 years ago, his wife of 38 years had died. Margaret. Cancer. Slow and then fast. The kind that gives you time to prepare and takes the preparation away from you anyway. He had used most of his savings on her care in the final 18 months. The gaps that insurance did not cover. The specialists who offered hope even when the hope was thin. The small comforts that money could buy when nothing else could be bought. He did not regret spending the savings. He said that specifically, without my asking. I would do it again, he said, every dollar. After she died, he had struggled in ways he had not anticipated. Grief, he said, is its own kind of disability. It does not show up on a medical chart, but it affects judgment and memory and the basic administrative tasks of living in ways that compound. He had fallen behind on his property taxes. He had not understood until it was nearly too late how quickly a modest, unpaid balance compounds with penalties and interest into something unmanageable. He had lost the house 18 months ago, the house he and Margaret had bought together 30 years earlier, the house where they had raised 2 children who now lived in other states with their own families and their own struggles, and had not, Walter noted without bitterness, been in a position to help. He had moved into his car. The car had been repossessed 4 months ago when a temporary maintenance job had ended and he could not make the payment. He had been on the street, intermittently in shelters when space was available, for approximately 4 months. He said, I'm not telling you this for sympathy, Your Honor. I'm telling you because you asked, and because I don't think a man should be ashamed of what happened to him when he did everything right and life happened anyway. I sat with that for a moment. I said, Mr. Henley, you mentioned a photograph in your folder. May I ask what it is? He opened the folder. He removed a photograph and held it up, not for the courtroom, just so I could see it from the bench. It was a photograph of a younger Walter Henley, in uniform, standing beside a woman in a simple dress, both of them laughing at a wedding reception that had clearly been modest and clearly been happy. He said, That's Margaret, my wife. I keep it with me. It reminds me who I was building toward, even on the bad days. He put the photograph back in the folder, carefully, the way you handle something irreplaceable. I looked at Tyler Bregman. I said, Mr. Bregman, I want you to hear what I just heard. A man who served this country for 22 years, who built a stable life for himself and his wife for decades after his service, who lost nearly everything, not through any failure of character, but through grief and a cascade of circumstances that can happen to anyone, and who 4 months ago ended up sitting against a wall because he had nowhere else to be. I said, and you stepped over him, called him something I am not going to repeat in this courtroom, and pushed him hard enough to break his wrist. I said, I am going to rule on the documented damages now, but I am also going to do something else. I issued the ruling. Full medical costs, full lost income, and additional damages reflecting the severity of the assault and the particular vulnerability of the victim, a 66-year-old man with documented circulation issues for whom the injury carried elevated risk and a longer recovery timeline. The total was substantial. Gregory Pierce did not contest it. He understood by that point in the hearing that contesting it would accomplish nothing. And then I did the thing I do not often do. I have a discretionary fund available to this court for certain circumstances. Emergency assistance in cases where a plaintiff's immediate welfare is directly implicated by the matter before me. I use it rarely. I had not used it in over a year. I used it that morning. I directed that Walter Henley be connected before he left the courthouse with the Veterans Services Coordinator who works with our court on exactly these kinds of cases. A connection that exists specifically for circumstances like Walter's, but that requires someone in the system to actually make the connection rather than letting a person fall through it. I directed emergency housing assistance through that office, effective immediately, not contingent on the civil judgment being collected, which can take time. I said on the record, Mr. Henley, the ruling will provide you with money you are owed, but money owed and money received are not always the same thing on the timeline a person needs, and you need housing now, not in 6 months when collections processes have run their course. I am connecting you with people who can help with that today. Walter Henley, who had been composed through the entire hearing, who had described his wife's death and the loss of his home, and 4 months on the street, without his voice breaking once, put his good hand over his eyes for a moment. He said, "Thank you, Your Honor. I wasn't expecting that." I said, "I know you weren't. That's part of why I did it." I have thought about January 14th many times since it happened. I think about Walter's handwritten paragraph. I have learned not to expect much. I would appreciate it if this court would not teach me that lesson again. I think about what it costs a person to write a sentence like that, what it requires in terms of accumulated disappointment, of systems that did not show up, of promises implied by 22 years of service that were not, in the years since, consistently honored. I think about the photograph. Margaret, laughing, at a wedding reception that had clearly been modest and clearly been happy. 38 years of marriage, a house paid off, over 26 years of on-time payments, 2 children raised, a pension earned through honest, steady work. By every measure that this country claims to value, Walter Henley had done everything correctly, and it had not been enough to protect him from what grief and a compounding tax penalty and a repossessed car could do in 18 months. I think about Tyler Bregman, 23 years old, who could not finish the sentence he started. He's just old, I didn't think, because finishing it would have required him to say out loud the assumption underneath his actions that some people's safety, some people's bodies, some people's dignity matter less than others when they are inconvenient. I do not believe Tyler woke up that morning intending to injure anyone. I believe he had simply never been taught by anyone in 23 years of presumably comfortable life that the man sitting against a wall with a cardboard sign was a person whose life had a shape and a history, and a wife named Margaret, and 22 years of service, and 31 years of honest work after that. He had been taught by the specific blindness that comes from never having to look closely at people who are easy to look past, that Walter was an obstacle rather than a person, a thing in the way rather than a man who had served, who had loved, who had buried a wife and lost a house, and was still, somehow, pressing his shirt by hand before walking 2 miles to ask a court for what the law owed him and nothing more. The ruling addressed the financial harm. I believe it addressed it fully and fairly. But I think about what I did after the ruling more than I think about the ruling itself. Because the ruling, by itself, would have given Walter Henley a judgment that takes time to collect and does nothing about where he sleeps tonight. The system working exactly as designed, would have processed his case correctly and still left him on the street for months while the wheels turned. I did not want that to be the outcome of January 14th. I think about what it means that this court has a discretionary fund for moments exactly like this one, and that I use it so rarely. I think about how many Walter Henleys have come through courtrooms, not just mine, every courtroom in this country, and received a correct ruling and an empty stomach and nowhere to sleep that night, because the ruling and the rescue are not the same thing, and only one of them is usually offered. I have since learned through the Veterans Coordinator who took Walter's case that day that he was placed in transitional housing within 72 hours, that he has since connected with a Veterans Employment Program, that the trajectory, as of the last update I received, looks different than it did on January 14th. I do not know how his story ends. I am not certain anyone's story has an ending while they are still living it. But I know how it was on the morning of January 14th, and I know it looks different now. And I know that the difference came from a courtroom deciding that a correct ruling was the floor of what was owed, not the ceiling. Now I need something from you. If you have ever walked past someone who was sitting against a wall with a sign, I am not going to tell you what to do about it. That is a complicated question with no single right answer, and I am not going to pretend otherwise. But I will ask you to do one thing. Remember that the person sitting there has a history, a service record possibly, a wife named Margaret possibly, a pension and a house, and 31 years of honest work possibly, before grief and bad luck and a system with very few safety nets took it all away faster than anyone expects. Share this video with someone who needs to be reminded of that. Share it with someone who has stepped over someone the way Tyler Bregman did, without thinking, without seeing. Subscribe to this channel. I have 40 years of mornings, and this one changed how I think about what a courtroom is actually for. And tell me in the comments, if you were the judge that morning, what would you have done differently? I genuinely want to know. I read every single one. Walter Henley walked 2 miles to my courtroom on January 14th because he did not have bus fare. He left with a ruling, a roof, and a photograph of his wife still in his folder, exactly where he had kept it the whole time. That is what January 14th became.